A powerful federal court order has just rocked both Manhattan and Washington, sending shockwaves through political and financial circles. Several of Donald Trump's most valuable properties, including the iconic Trump Tower on Fifth Avenue, are now facing immediate confiscation to cover a massive $464 million court judgment. This is not a temporary hold or paperwork delay. This is the real takeover of real estate assets tied to Trump's personal brand for decades. When a New York judge authorizes the government to start selling properties worth hundreds of millions of dollars, it signals something completely unprecedented for a former U.S. president. Stay tuned because this situation is far from over. So how did it reach this point? On January 18th, Judge Arthur Engoron ruled that Trump's failure to provide the legally required appeal bond was a direct act of defiance against the court's February 2024 fraud ruling. Court filings from New York Attorney General Letitia James show Trump had more than 11 months to secure the bond or arrange payment. Instead, he rejected every compromise offered. This is no routine legal loss or political argument. Even members of Trump's own legal team have privately admitted that the case has entered a dangerous stage. When a judge moves from issuing warnings to ordering asset seizures, it means the situation has reached a breaking point. Tensions between Trump and New York authorities have been growing since late 2022, driven by the Attorney General's civil fraud case, Trump's confrontational courtroom conduct, and repeated failures to meet legal deadlines. Everything intensified on January 18, 2026, when Judge Engoron signed an enforcement order listing 7 Trump-owned properties for immediate seizure. These include commercial spaces in Trump Tower, his golf resort in Westchester County, and his Wall Street office building. This was not about bookkeeping errors or technical mistakes. The ruling stated that Trump exaggerated property values by more than $2.2 billion to obtain favorable loans, misleading banks and insurers through a long-running pattern of false financial reporting. The conduct was described as so severe that Trump's own accounting firm withdrew its certifications and cut ties with him. Once the Attorney General received legal authority to act, her office moved quickly. Notices were sent to Trump Tower's property managers, and major tenants were informed that ownership would soon change. Sources familiar with the process told Reuters that officials were moving unusually fast, expecting resistance. Court-ordered property seizures involving a former president are almost unheard of. They occur only when a judge determines that a defendant has ignored every opportunity to comply voluntarily. The day before the order was signed, Trump's legal team reportedly gathered at Mar-a-Lago for an emergency meeting. According to sources cited by the New York Times, his lawyers warned him that the judge's patience had run out and that property seizures would begin within 2 days unless he posted at least part of the bond. Trump allegedly brushed off the warnings, believing higher courts or political allies would stop New York from acting. By the evening of January 18th, the judge authorized the Attorney General to begin taking control of Trump's properties to satisfy the judgment, which had grown with interest to nearly $478 million. The order said Trump's repeated refusal to obey court instructions showed intentional contempt and required immediate enforcement. The next morning, officials from the Attorney General's office arrived at Trump Tower without warning, carrying court documents and escorted by sheriff's deputies. According to building staff who spoke to CNN, they informed management that the state was assuming control of the commercial area's pending sale. Witnesses described a surreal scene as state officials established operations inside the building, and Trump Organization employees were told they no longer had decision-making authority. One longtime manager said he never imagined he would see government officials take over the building in broad daylight. Trump Tower, the skyscraper built in 1983 and long seen as the centerpiece of Trump's business image, was now being stripped from his control by court order. Later that day, Attorney General Letitia James held a press conference outside the courthouse. She confirmed that her office had officially taken possession of Trump Tower's commercial floors and would begin selling them to recover the unpaid judgment. The announcement stunned real estate leaders and Republican officials alike. When a state attorney general publicly seizes property from a former president, it sends a clear message. The law is being applied the same way it would be to any other person who refuses to pay a court-ordered judgment. Trump has faced financial threats before. In 1990, his Atlantic City casinos collapsed and creditors nearly seized his personal assets. He avoided losing major holdings by restructuring his debts at the last minute. In 2006, lawsuits over Trump University sought to freeze his assets, but he settled the case in 2016 for $25 million and avoided seizure. In the E. Jean Carroll defamation case, Trump posted an appeal bond within weeks after an $83.3 million verdict in 2024. This time, however, he refused to do so despite having nearly a year. Legal experts say this refusal violated basic rules of civil procedure. The judge noted that Trump failed to post a bond, failed to arrange a payment schedule, and made no serious attempt to comply. Under New York law, when a debtor refuses to pay, the state can seize and sell property. The order also cited Trump's public statements declaring he would never pay the judgment as proof of bad faith. It referenced his social media posts boasting about wealth while claiming he could not afford the bond. The judge called this position contradictory and evidence of deliberate resistance rather than true financial hardship. Court-appointed monitors estimated Trump's available cash at more than $400 million. The issue was not ability, it was refusal. This case goes beyond a single judgment. If a former president can openly ignore court orders for nearly a year without consequences, the authority of the legal system is weakened for everyone. Allowing that precedent would mean future defendants could claim the same immunity. Trump's legal and political teams now face a severe dilemma, with enforcement already underway and few options left to stop it. Trump's team is now trapped between two dangerous paths. On one side, his political supporters are demanding full resistance, insisting this is nothing but political revenge and proof that the legal system has been turned into a weapon against him. That strategy means continuing to challenge the court, publicly attacking Judge Engoron, and portraying the property seizure as an unlawful attack on Trump's rights. On the other side is a harsh financial reality. Banks, lenders, and corporate partners are paying close attention. When they see properties taken and sold because Trump refused to post a routine appeal bond, they don't see persecution. They see someone who doesn't follow standard business or legal practices. And this is where the problem becomes unavoidable. There is no convincing excuse. Either Trump truly cannot raise a $464 million bond, which would mean his claims of enormous wealth are exaggerated, or he can afford it and is simply refusing, which places him in direct violation of court authority and makes seizure the proper legal response. Courts have already dismissed his claim that the bond amount is unfair. Appellate judges ruled unanimously that the bond requirement matches the size of the judgment and follows normal procedure. Legal scholars are calling this a turning point for accountability. Barbara McQuaid, a former U.S. attorney and law professor at the University of Michigan, said on MSNBC that if the seizure order is enforced, it proves that political power does not place anyone above the law. She noted that property seizures happen regularly in New York civil cases, but never before involving a former president, which gives the situation historic weight. Andrew Weissman, former FBI general counsel and a prosecutor in the Mueller probe, added that Trump made a fatal misjudgment by assuming courts would never actually take his properties. He warned that Trump may end up losing assets worth far more than the original judgment because forced sales usually happen at deep discounts.